Hi, everybody. Good afternoon, and welcome to the 2021 Umbrella Trends for Community Associations webinar. I'm Marketing Manager Sherry Branson. I'm now joined by the founder of Kevin Davis Insurance, Mr. Kevin Davis, and Kevin joins me from Los Angeles. Hey, Kevin.
Well, actually, from New York City, so
Oh, okay, that's right. You're on the East Coast. That's
on the
right.
East
Kevin's
Coast
on the
this
East
week.
Coast.
Yes, yes.
He's
Got the
bi-coastal.
COVID shots, and I can travel again.
Yay! Congratulations. That's great news. That's great news. It must be a relief.
Yes, it is. I can actually sleep at night now, so everything is really a lot better now. That's for sure. Yeah, yeah,
Yeah. Oh, fantastic. Yeah, we hope everybody's staying healthy out there and
yeah.
doing well and getting vaccinated as fast as you can. And
And staying safe. We gotta stay safe.
stay safe, exactly. Stay safe and stay healthy. And Kevin, we have a really interesting topic to talk about today, and we've got like almost 200 people joining us, so we have a nice sized group. And what is our goal? What are we trying to accomplish today?
Sure. You know what? Today we're going to hopefully answer some questions about what's going on in the umbrella marketplace. There's some trends that we're actually seeing now that really is taking this whole industry in totally different directions, and we're going to talk about them today, and hopefully we can kind of clarify what's happening out there.
Absolutely, absolutely. I did want to mention a couple of things. If you have any questions about what we go over today, there's a questions box on the right side of your screen. You can just type your questions into that box. And if we have time at the end of the session, we'll answer your questions. If not, I'll send you an email or give you a phone call to answer them. And I also record all of our webinars and put them on our website, which is kdisonline.com, where you can listen to today's webinar and all of our past webinars going back 10 years. So we have quite a few webinars on our website, so feel free to listen to them at any point. And if you'd like a copy of the PowerPoint and a copy of the recording, the link to listen to the recording, I'll have it ready by Monday. So please send me an email to sbranson@kdins.com. That's sbranson@kdins.com. It takes a while to download the file because the video file is very large. So great. So Kevin, so let's talk about, what's going on? What happened? Why is Umbrella changing so much?
Well, right now, I would say the umbrella market's in total disarray. We don't really can't tell who's doing what anymore, what players are doing, what they're looking for and not looking for. And if you look at it from a historical point of view, it's been way too long that all these like 15 to 20 umbrella carriers over the past 15, 20 years that specialize in real estate. And they offered like $50 million limits, $250 million, $300 million limits. And, for premiums like $3,000, $4,000. And it happened so long that, it's starting to catch up with itself. We're at a point in time now where only a handful of carriers left that focuses in on community association for these large limit umbrellas.
Okay, so the market has really shrunk. A lot of people have dropped out of the umbrella market for community associations. And I guess the basic reason, it's pretty simple, it's profitability.
Yeah, and that's what it boils down to. It's profitability. The carriers are saying we're not making enough money in these situations. We're giving out way too much limit and not enough money for it. And when we talk about, for us, for community association specialists, it boils down to two things. Two things that happen. We talk about trends. There are two trends that really goes to the number of claim damages that are out there, the reduced coverage that we're seeing, the lower limits, and that is social inflation, which leads to something called nuclear verdicts, and the expanded responsibility of serving on the board of directors of a community association. That's it. That's where we're at right now, and that's what's causing a lot of our issues.
Yeah, there's so much more responsibility on the shoulders of board members now than ever before. And social inflation, we've talked about that, and that's kind of a buzzword right now in insurance. I've seen it all over. What exactly is social inflation?
Sure. When we talk about social inflation is this term used by the insurers out there, all these insurer providers that describe the rising costs of insurance claims and trends and costs, okay? But they're caused by social and economic trends, as opposed to before, historically, they were caused by other situations. Here, it is all social and economic trends, which results in either more litigation and larger jury awards. I mean, Really, at one time, $100 million judgment was unheard of, but now it happens a lot. The slip and fall was once like a $300,000 claim. Now we're seeing for a minimum at 1.5 million.
Mm-hmm. And I've even seen several $billion verdicts over the past year, which demonstrates how that's affecting the insurance industry. I mean, it's just really
Exactly. Because social inflation has led to a rise in insurance costs across the board. I'm talking about umbrella. I'm talking about D&O, auto, environmental. As a result, you're seeing carriers out there looking at these things and reducing coverage, raising rates, increasing deductibles, putting exclusion on the policy. And social inflation is that number one factor out there that's causing it.
Mm-hmm. And now when we talk about social inflation, what's behind that? What's causing it?
Okay. Well, there's four things really causing social inflation. The first one is the mistrust of corporations. Many individuals just do not trust the corporation out there to do the right thing. And all decisions that these corporations make are there for one reason, make them profitable. I mean, they really don't care about the common good. So this creates a place right now where people want to hire attorney and file lawsuits to get back at those corporations.
Mm-hmm, absolutely. And to make matters a little bit worse, Kevin, when people serve on a jury and they have to decide who to believe, they are increasingly likely to believe the individual the person over the corporation, whether the facts of the case support it or not. They usually go for the little guy. They think the corporation's the big bad wolf, so to speak.
Yes, exactly. And that's what really creates that problem. That jury pool is looking at them and saying, let's penalize the corporation, the big bad corporations, penalize them. So that's the first one. The second reason is this plaintiff attorneys have gotten a lot smarter. I mean, we all see how smart these guys have gotten.
Yeah, they're advertising and marketing their specialty more and more, and they have a very sophisticated data analysis system to target their clients, so they know exactly who to go after.
Yeah, and what they're really doing is kind of interesting. Also, they're actually using the policy limits there as a wedge to say settle it down. So they know you have a $5 million umbrella policy or $10 million or $1 million. They just go in there and say, listen, you got the coverage. Let's just settle it down and get it out of the way. So it's really, really creating a problem. The third is the use of emotions to influence the jurors out there. I mean, they really just doing it a lot these days.
Mm-hmm. Yeah, I noticed that the attorneys are focusing on the quote, heartless corporations as a way to scare the jury into these large verdicts.
Yeah. And they put that question to the jury and they let them know, hey, if you're in that position, don't you believe that you should penalize the big bad corporations? So again, it's more emotionally based. Again, the amount of time and energy these lawyers are putting into it has led to, again, social inflation and the need for spend more money and higher limits. And the fourth one is changes in the legal environment itself. That changes, it's really have made some big differences.
Mm-hmm, absolutely. And there's generational shifts too, Kevin, as millennials have taken over the juries, and they tend to be more concerned with privacy, with climate justice and climate change and pay inequity and other social and environmental issues. So any lawsuits that touch on these issues could trigger a really large verdict.
Yeah. And you know what? And the reality is that you got a lot of these jurors too are just desensitized by these awards. I mean, throughout 10, 15, $1 billion, all these different numbers, it just doesn't mean anything as much as it used to. They're desensitized by it. And for insurance companies, for the carriers out there, how do you predict? How do you predict what limit to put out there when we have no idea what social trends are going to happen over the next 12 months? I mean, look at the social trends developed over the past 12 months last year. I mean, the claims that we're going to see over the past 12 months are going to just be astronomical based on, again, the social trends and economic conditions that we're seeing always will affect the claim.
Mm-hmm, absolutely. Yeah, nobody saw COVID-19 coming. I mean, there's no way to predict anything happening really over the next year. And we talked in the beginning of today's webinar about nuclear verdicts. What exactly are nuclear verdicts? That's a new term that we haven't heard in the past.
So from a social inflation, again, has led to the rise of the amount that's being paid out, these awards, these judgments. And a nuclear verdict is a large award, basically a large verdict. And any verdict over $10 million is considered a nuclear verdict these days. Okay.
10 million. Okay, that's a big one. Yeah.
Yeah. The first nuclear verdict was 2011, where $40 million was awarded to a victim, an individual in a car crash in Georgia, where due to driver negligence. I mean, since then, I mean, there have been numerous, cases in, the tens of millions of dollars. It's not a big deal anymore. And recently, okay, recently, we talk about nuclear verdict. A jury awarded an injured motorcyclist $411 million in damages upon hearing the case on Zoom.
On Zoom. So this was the first, this was one of the largest amounts in damages, right? Awarded in a Zoom trial.
Yeah.
So now it's also held on Zoom.
That's the point, $411 million for motorcyclists on Zoom. And again, this is what we're seeing right now. Again, 2011, a $40 million awarded as a victim of a truck crash. They have a $411 million. That's the difference it's been in. That's right now, that's the number one trend that we're seeing that's really impacting, community associations, the umbrella market, insurance market in general, is social inflation. It's just getting, and that's getting worse and worse.
It's getting bigger and bigger, affecting it more and more. I did want to mention my email one more time. If you wanted a copy of today's recording and a copy of the PowerPoint, my email is sbranson@kdins.com. So feel free to email me if you'd like a copy of the recording and the PowerPoint. Great. And then we have some other examples up here, Kevin. I don't know if you wanted to talk about those a little bit. Some of these large.
They speak for themselves. They speak for themselves.
Yeah, $8 billion, Johnson & Johnson for Risperdal, and just billions, and it's just, they're getting so large, and everybody's getting affected by it. Now, Kevin, though, always serving on a board of directors has always had some level of exposure, to liability, of course. But why is there an increase in exposure for board members serving on the board? Why is it getting worse?
Definitely. All right, right now, there's been a fundamental change for individuals serving on community association board of directors. It has changed recently over the past several years. The responsibility of the board has gotten really a lot more complex. And again, that complex leads to more exposure, and more exposure means more liability, more number of claims. And there's two issues I'm really concerned about. The first issue is how now the community association has to focus in and make sure that the health, safety, and welfare of the association is a major concern.
That makes sense.
The second one is rule enforcement based on questionable authority, meaning that do they have the authority to enforce these rules or not? So those are the two most important things we're talking about. So again, it is about how you're going to run the association, health, safety, and welfare, and enforcing the rules, the documents of the association. Because it's, boards, directors of these community associations operate as they run a business like we treat any business, meaning that we talk about budgeting, rules enforcement, and maintenance. However, board members now have to worry and be concerned for the health, safety, and welfare of the community in parts were never part of the government documents, never part of state condominium laws or anything like that. For example, COVID-19 created a major concern for community associations across the country. I mean, it's created a historical problem that set a whole new problems that we haven't even know the results of them yet. A good example of this one was Palmetto Place Condominium Association. Palmetto Place Condominium Association, okay? This was an association in Florida where they actually, board of directors, deactivated the key fob of the individual units who lived there because they tested positive for COVID-19. Okay?
Incredible.
Yeah, so it's one of those associations where in order to get access to your unit, you have to swipe the key fob like you do in a hotel. Well, deactivated it and told them that if they ever tried to leave there, they would call the cops.
Oh, so they're basically keeping them prisoner in their own condo.
Exactly. So they end up suing the board of directors for false imprisonment, invasion of privacy, negligence, violation of laws. And they said that, again, the board didn't have the authority to impose these strict rules. And again, that is the problem. The board has to be responsible for the health, safety, and welfare of that community. They know somebody has COVID-19. What do? What kind of authority you have? You don't know.
Right. That's the big question. That's the million-dollar question. You know, Kevin, you know, whether we're dealing with COVID issues or climate issues, like just what happened in Texas with the frozen pipes and the water, they're having to boil the water. California has wildfires all the time with the wildfire season. You know, these are affecting community associations across the country by increasing the board members' exposure to loss.
Again, think about what happened in Texas. You lived in Texas, Sherry. All
Right.
of the frozen in your community association. What do you do about it? You know, we had all these wildfires out in California. You know, how do you do it? What do you tell them? What are the rules you set up for it? Well, most associations do not have rules. They don't have policy that says this is what we're going to do next, and where the authority come from to say what do you have to do next. So that was create this whole area of concern that now lawsuits are happening. Okay, judgments are being paid. Now, yeah, that's the first concern. The second concern now is the association's responsibility to enforce these complicated rules. Okay, rules like harassment and bullying and hate crimes, public and private nuisances that are happening out there. It is their job to really enforce it.
Absolutely. I mean, they've always had to enforce things like noise claims and noise situations, and smoke is also another nuisance that they've always had to address. Again, these documents don't always address these new exposures that have been popping up left and right.
Yeah, but even though they had different, like you said, you know, like smoke, okay, now we get a claim for not only just the smoke in it, but marijuana smoke, okay? These not had in the past, you know? I smell
Right.
marijuana smoke, not just cigarette smoke, marijuana smoke. So there are issues here that the board of directors never had to deal with before. And that just creates the problem. And you have something like bullying, which is a major problem in community associations, you know? And what this board of directors used to do historically was say, hey, it's a private matter between two neighbors. We're not going to do anything about it. But they have to now, you know? Especially you look at community association today and they're dealing with problems like racism and harassment, and they do want to ignore them. The problem is that you can't. I mean, they don't know what to do. They're not sure what to do, and they get afraid that if they start doing something about it, they'll become the bad guys, and they'll start, you know, harassing them and making comments against them and bullying them. So what they do, they just hope the bad behavior goes away and subside on their own. And guess what happens? It usually doesn't.
Absolutely. Yeah, and if the board doesn't properly address these issues and deal with them head on, you know, they could involve things like libel, slander, discrimination, harassment, as we talked about harassment. And if they don't act on these issues, it could get very expensive.
One of the big issues we're seeing a lot, that, again, was never an issue before, is social media. You know, Facebook and all those different things that they have out there. This is becoming a new vibrant area of conduct claims we're seeing against community association, because most associations have no social media policy. Then they expose the association to defamation and to all kind of liability.
Absolutely. I know, do you have an example of that, Kevin, to tell us about, you know, what you've seen on social?
Yeah, definitely. We had a $2 million judgment was paid to a former employee in an HOA, because what happened is the association allowed a property manager to go in and target, you know, this employee on social media platforms. He ended up accusing that person of being a pedophile and a drunk on a job. So they just published it in there.
Wow. Okay, so what happened with that case, Kevin?
$2 million was paid out on it.
2 million. Okay, $2 million.
Yeah.
$2 million for harassment on Facebook, for a harassment case. Something incredible. And I can just think of something that just happened recently in my homeowners association, where we have these stations where people can get plastic bags to pick up their dog mess in the neighborhood. And somebody wasn't picking up their dog mess, and somebody videotaped the person walking their dog and not picking up the mess and put it on our Facebook page. You know, so the administrator said, you have to take that down, you know, that could be slander. So they're basically trying to shame that person that they weren't picking up the dog after the dog.
And that's what happened. Can you imagine people in this association walking around with cameras and putting things on Facebook, and all of a sudden you end up with, again, a $2 million lawsuit against them. These are things that hasn't happened in the past. And so, see, you see now that serving the Community Association Board of Directors has changed. In the past, they were about maintenance work, landscaping, repair. Now it's expanded into areas that you never imagined before.
Absolutely. Yeah, we're at the point where people who live in these homeowners associations and these condo associations feel that their point of view is the best one or the only one, and it should, that's the only one that should ever be considered,
Yeah. They believe they have a right to use the pool or the gym or bring guests in or use Airbnb or rent their place out anytime they want to. They believe they have that. They have that right. And that's what it is. They feel that because they feel that it's right, regardless of the governing documents, regardless of state law, or regardless of just being a good, decent neighbor.
Absolutely. And the interesting thing, Kevin, is that many people in this group have never even read the governing documents.
Yeah, or even attended a board meeting. Yeah.
Right, exactly. Or attended a board meeting. They don't know what's in the documents, so they're not even aware that they're violating them. And then, and then it becomes an issue and they say, well, why can't I do this? Or why do I have to do that?
And again, this has led to an increase in Fair Housing Act claims based on discrimination, harassment by unit owners against other unit owners against board members, unit owners against contractors, property manager. It is big. It's becoming big. Again, due to the feeling of being right, we're seeing more and more claims and awards being paid out. They feel it's right. That makes them right, regardless of what the documents are saying.
Which has led to a lot of poor underwriting results, right, Kevin?
And that's the key, and that's what we're talking about right now. Those two issues alone: social inflation, the responsibilities of the board, left to poor underwriting results. And if you look at this chart here, where do the claims come from? And that's what people ask me: where do these claims come from? Well, for some reason, it's around a lot of water. Okay, so if you live on the East Coast, anything east of I-95 from Maine all the way to the Florida Keys, you live east of there, you're going to have a claim. You're going to have a big claim. It's going to happen. Okay. If you are on the West Coast, okay, and there's Interstate 5 that goes up to all the way from Washington State to California, if anything west there, you're going to see claims. You're going to see a lot of claims, and that is where most of your problems come from. California leads the way in one area. Florida leaves the area in the other area, but hey, just all up and down the coast. The more you move inland, the less major awards you have. So if you live in any of those areas, if you insure association in those areas, make sure you have high limits. And also too, you have the Gulf of Mexico there, which is water. You also have the Great Lakes of Chicago. So wherever there's around a lot of water, for some reason, I don't know, people don't like each other too much.
The only thing I can think of, well, one factor, I have a feeling there's a lot of lawyers that live in the areas around the water. That's probably.
Yeah. I think when climate change comes in, they kind of get rid of all those guys out there.
Exactly.
But that really is the problem right now. You're looking at it, and it's in those areas. And as underwriters, we're looking at those areas there and saying, those areas right there are harming the rest of the program. So what do you do about it? And again, these are things that we have to deal with on a daily basis.
Absolutely. And now let's talk about some of the exposures, Kevin. We talked about some of the exposures already, but more exposures that create problems for associations specifically.
Sure. Historically, okay, we're talking about accounts that these exposures that created problems for community associations, over time. Fire, water, maintenance, breach of fiduciary duty. Again, but we're seeing unique things that we haven't seen before. Okay, from a fire, we're talking about as a robbery where somebody broke into somebody's unit. The person was selling jewelry out of the unit. They stole the jewelry, set the place on fire. Well, he sued the board like normally would do because he didn't have adequate security, wasn't adequate lighting, but also sued because they didn't force the documents. They allowed him to sell the unit. They knew he was selling jewelry out of his unit, and they continued to do that.
So they weren't enforcing the documents, so they got sued on top of that. Interesting.
Yeah, and then you have water, lots of water, lots of slips and falls, a lot of sewer backups, things like that, and maintenance. Maintenance is a really major problem for community associations out there, because you will see that the association is responsible for maintaining the common area. When they don't maintain it, they'll get sued. If they do maintain it and don't maintain it correctly, they'll get sued. And then you also have breach of fiduciary duty, which is the catch-all of everything. So whenever the board does something wrong, all of a sudden it's like the board breached their fiduciary duty because they did not do X, whatever X was at this point in time. So the major things that we've seen, and we've always seen. The problem is now, we're seeing new things, but the awards are larger. I mean, we're talking about some incredible awards, but again, the days are gone when you have a $1 million lawsuit or $1 million claim. Here we go. Here's a case, right? $41 million is awarded to a former Security Exchange Commission official, right, out of Palm Beach County, who suffered a injury on a bicycle crash. So a bicycle crash in an HOA. He claimed the organization erected these scaffolds there, but didn't put proper markings on there. So as a result, he got in a terrible accident. And again, he was awarded $41 million.
Multi-million-dollar lawsuit. Incredible.
Yeah.
Just because it was, with the sign there, that would have been the warning. So he would have, if he ignored the warning, but there was no sign. So that was on the HOA. And
again, he had another one, a $30 million, $30.7 million, $30,700,000, where 3 children fell through the ice, or one of them fell through the ice. The other one tried to help him out, and one passed away. So he had 3 children, but they were awarded $30 million because the association's lake, they were responsible for the lake, but they didn't put any signs up, no sign. And a $70 sign would have made a difference for these kids. And they, as a result, they were awarded $30 million.
And I highly doubt that many of these associations have $30 and $40 million worth of coverage.
Exactly. And that's the point. Here's another one. Here's a $12 million suit against association again. Here's a person who was hit, a driver driving on a bicycle case. But what happened was association is a failure to maintain situation where the hedge was twice the size as allowed by law, and the stop sign was a little bit shorter than it should have been. So again, $12 million judgment against them.
Incredible.
Judgment against a lady who, a 40-foot tree fell on a woman while she parked her car in a carport. So the carport was there. Tree fell on top of it, awarded $10 million. This was the second tree to fall on that same carport in 3 years. That's why it was awarded $10 million.
$10 million. Wow.
What we're seeing, Sherry, is these larger awards for clients that used to be settled for hundreds of thousands of dollars are now then in tens of millions. Today, we believe that owners are quick to sue because the lawsuits can mean big awards.
They see it in the news and they think, well, I can sue for that amount as well, for 10 million or 40 million or anything as high as they can go. So basically, Kevin, what you're saying is, these large nuclear verdicts and lawsuits are ending broad coverage and high limits for very low rates, which is what the umbrella market used to be.
The world has changed. The world has changed. Things that happen that they haven't happened before. It's a real difficult time for people looking for these high limits. All right. It is. Okay, think about this. What if association you're insured? The people who are listening to this webinar, you are agents. What if you're insured a suit and had to pay millions of dollars from a drowning, or millions of dollars from slip and fall, or breach of fiduciary duty, and you had a $1 million GL policy? Knowing that an umbrella policy would make a difference for protecting association's funds. I mean, you know that, right?
Yeah.
Are you the ones who are going to let them know that, there has to be a special assessment to charge $40,000 to each member there, or you have to drain your reserve account, or you have to sell off all your assets you have in your rec center to pay the, 30 or $40 million you have to do it?
Yeah, no, I wouldn't want to be the one to tell them to have to sell everything in the rec center. That's for sure.
And that's what we're talking about today. Even though it's difficult to get some of these things, you don't have a choice. Just think about the number of unit owners, renters, managers, suppliers, contractors, employees who comes into a community association on a daily basis. And it's the responsibility of the people who run that association these people who are inexperienced and don't have the knowledge and everything to protect them against any kind of wrongful act, personal injury, bodily injury, or property damage. And they only have a $1 million limit.
Mm.
Yeah. It doesn't make any sense.
It doesn't make any sense, and not with all the amenities that these associations have now, like pools and ponds and lakes and rec centers, et cetera. I mean, it really increases the chance for a large loss, right, Kevin?
Yeah, and that's why you have to have a high limit. It's peace of mind insurance for your community association. It provides the protection they need of your GL, the employer's liability, auto, and your D&O. So it's protection for these catastrophic losses that we just talked about. So you got to have it. So the question is, what's changed? What's changed out there? And how can we make a difference? And it boils down to these couple things right here that you're looking at right here. Number one, do you have a true umbrella policy? Okay, there's a difference between a true umbrella and a straight excess policy. If you have a straight excess, that means it follows form whatever the primary policy is. If you have a true excess, it follows form. If you have a straight excess, the straight excess may have their own conditions in there, own exclusions in there that won't pick up no matter what the primary does. If you have a true umbrella, it drops down, but only a true umbrella. So you have to really go do some research and find out, do you have a true umbrella? Do you have a straight excess? Do you have a follow form excess? It is questions you need to ask, because at the end of the day, if you're sued for discrimination, okay, and there's no discrimination coverage under your primary GL policy, but it could be picked up under an umbrella if you had a true umbrella, but you have excess, you're in trouble. So you got to make sure you have an umbrella, not an excess policy. Limits used to be available, they still are. You got to figure out what limits you want to do and make sure you get the best deal you can get for your client. You don't need, do you need $200 million? I don't know. But you got to get more than the 5 or the 1 or whatever. Make sure your umbrella goes over to D&O and APLI, because that's where your exposure's at. A lot of these things are D&O exposure that we're talking about, not only general liability, but you got to make sure that they do that. See? Underwriting itself is taking longer. They were worried about this extreme exposure we talked about earlier, like lakes, okay, like ponds, like rec centers, like pools that are properly fenced. So underwriting takes a lot longer than it used to. We're not, it's not, the days are gone when you felt an accident and then you can get coverage bound. It's going to take time. Complicated apartments, watch out for it. We can do apartments, but the more complicated they are, the harder it's going to get. We're seeing a lot of surplus line carriers out there right now that are writing these coverages, the primary coverages. We got to be careful. Do we want to go over them or not? Because those surplus line carriers may exclude personal injury on it, may not pick up some of the things that we want to pick up, and then the umbrella has to drop down on it. So we have to, it's going to take a little more effort, things like short-term rentals and Airbnb and hotels, mixed use associations. The things that used to be able to do, pretty easily, it has gotten really, really tough and really, really complicated. Loss history is a problem right now because you're looking at some of these community associations that has crime issues in there. We see a lot of shootings and robberies and things. So again, things have changed. The world has changed. We're living close together now because of COVID. We're on top of each other. As a result, we're not as happy as we once were with it. We were rather happy to begin with, but it seems like we're less happy than we were before. So that's the problem with umbrella right now. I think what we need to do is realize, be a little bit patient, but make sure we understand that there are exposures out there and you do need a large limit umbrella more than you ever needed in the past. So.
Absolutely. The claims are bigger than ever with all the nuclear attacks going on. Great. Thank you, Kevin. And I did want to mention again, if you have any questions about what we went over today, feel free to type your questions into the questions box. And it looks like we did receive a few questions already. And I did want to mention a couple more things. Today's recording is going to be on our website, which is kdisonline.com. You can listen to the recording. If you'd like me to email you the recording on Monday, please send me an email, and I can email you the PowerPoint as well to sbranson@kdins.com. feel free to send me an email, and I'm happy to send you the recording and also the PowerPoint. And Kevin, we have a question from Megan A. Megan would like to know, are there any claim examples related specifically to community associations? And Megan, we just went over a few of them within today's webinar, a few very large verdicts. So just send me an email to sbranson@kdins.com, and I can send you a copy of today's PowerPoint, and I can also send you some more umbrella claims examples.
Sharon, I think what we'll do is change the PowerPoint and add them in the PowerPoint. There's like 4 or 5 cases in there. Before we put it in there, we'll update the PowerPoint.
Good idea. Yeah, we'll add them to the PowerPoint. So we'll send you the actual community association claims examples within the PowerPoint. Fantastic. And now Karen C, she'd like to know what has changed to make the associations now responsible for health, safety, and welfare of the members when this is not in their governing documents?
Sure, okay.
Great question, Karen, thank you.
COVID is #1 example. And again, what happens is if you think about COVID, now you have associations out there who have to follow the rules, okay? If the governor says you shut down, you can't have people coming in, you shut the pool, just something simple, shutting the pool down and shutting down the rec center, okay? They have to figure out how, and they do it for the health, safety, and welfare of the community. That's why they're doing it. They're not doing it because it's in the governing documents. They're doing it because the governor says that every corporation has to follow these rules. So now all of a sudden they're following. The problem though is that what happens, the governor says close it, but the city ordinance says to keep it open, like you have in Texas right now. In Texas, you have the governor say it's okay, you have the city says it's not okay, then you have community associations that says it's not okay. So that's the reason why they have to face these issues. They have to face an issue because without facing them, the community association will go in disarray. They have a choice. They either can just let it go or say, we need to protect the people who live there. And if they don't protect them, they'll be sued. If they allow everybody to go swimming, if they allow everybody to use these facilities, there will be a major lawsuit and no coverage because COVID is not picked up under any coverage. Those are bodily injuries. Yeah.
Yeah, that's a big issue. Like you said, in Texas right now, the city of Austin wants masks and they're doing their own thing, and then the state is doing another thing. So it's, you know, who do you follow as as a board member? Which laws? And then there could be different city laws as well.
And it's not in the governing documents. What do you do about it? What you have to do is determine what's best for your community association. And again, I would say go to your lawyer, and the lawyer will help you out on there. But again, they're not just enforcing the rules, doing the budget, and taking care of maintenance. Now they worry about making sure that people who live there are safe.
Safe, exactly.
Yes.
Especially if there's people in the community with COVID who tested positive as well. Great. And Kevin, we have a question from Norman H. He has an underwriting question. If you have a master GL policy, with each association as an additional named insured, so this is a master where each association is additional named insured, with a designated premises endorsement and uncapped aggregate per location, why can you not write an umbrella on it?
Okay. Yeah, right now is that we're looking at something, the word complicated comes to mind. When you hear the word complicated, that makes it a issue right now. It's complicated. Now, does that mean there's some complicated things we can do and something we can't do? I tell you right now, if it's complicated and if the effective date is anytime in the next 30 or 60 days, you know, within 30 days, it probably will say no. But if you have something that's probably, you know, gives enough time to look at it, talk to us about it, let us know that certain things, we may be able to do it. It is complicated. And right now, complicated means there's exposure out there that can end up with $30 or $40 million lawsuit against it, especially if it's North Coast. If it's in Washington, D.C. or Maryland or Virginia or New York City or South of North Carolina, any of those places, again, it's going to be a bigger problem than it is in Ohio.
Absolutely. Great. And we have another really good question from Scott M. Thank you, Scott, for your question. Scott would like to know, why are umbrella carriers so reluctant to quote timeshare resorts, timeshares?
Okay, well, what we're doing is we're looking at community association. We know there are people who live there who care about their community, okay? So we understand the exposures are there. Now, if you are a timeshare and you have people coming in and you leaving, then all of a sudden you realize that it is a certain kind of people who coming in and out of there. Okay, so it's really not designed for a community association program. And again, it gets complicated. We understand community associations. We know that the board of directors has a job to maintain. You're doing it as a volunteer. We know you have limited experience. So historically, because of the business judgment rule, you wouldn't get sued for millions and millions of dollars. Well, that's gone now. And so we need to make sure that we had that little box together so that, we've been around for 20 years now. Kevin Davis Insurance Service has been around for 20 years doing umbrellas and doing D&O nonstop for 20 years. We haven't had any issue. We want to be around for another 20 years. And all we can do is making sure that we underwrite these things thoroughly and make sure we do a pretty good job at protecting our carriers.
Mm-hmm. Absolutely. Great. Well, thank you. Thank you, Kevin.
That's it? Okay.
Yeah, thank you, everybody.
All right, so next month, what are we doing next month?
Yeah, next month, we're going to be doing a webinar on crime policy for community associations. So I'd like to thank Kevin for a great webinar today, and thank you everybody for joining us. We had a great group and some wonderful questions. And again, please send me an email to sbranson@kdins.com, and I'm happy to email you a link which is a recording of today's webinar and also our PowerPoint as well. Thanks everybody. Have a great Easter and happy Passover. Take care. Have a good afternoon. Bye-bye.
Thanks, Sherry. Bye.
Thank you. Bye-bye.